Welcome back. We're still telling your story on S8 today. Now, the Pietermaritzburg High Court has ruled in favor of the Independent Institution of Education's LLB degree and has given the Minister of Justice and Constitutional Development, Michael Masutha, 1 year to change the Legal Practice Act. Now, the ruling means that law graduates from private colleges are just as qualified to enter the legal profession in the same year as their counterparts from public universities. The judgment ends a period of anxiety for over 400 law students studying towards their LLBs at independent education institutions. For more on this story, I'm now joined in studio by Pieter Kriel, who's the General Manager of the Independent Institute of Education. Thanks so much for joining us. Welcome to the program.
Good evening, and thanks for having me.
All right, so you must be elated by this judgment, but first, let's go back to how we got into this situation in the first place.
Well, under the Higher Education Act, higher education institutions, both public and private, are expected to have the offerings accredited and then registered with the Department of Higher Education and Training, which we do as standard practice. I mean, if we don't, we're not legal. So the LLB degree was accredited by the Council of Higher Education in 2017, and we started offering it in 2018. During 2018, one of the student parents in the KwaZulu-Natal region had contact with the Law Society, who then alluded to the fact that according to the Legal Practice Act, the word university is used, and that only students coming from a university are able to enter the profession and therefore register as candidate attorneys. And therefore we picked up on that at the time, and we started the case and discussions with the Law Society, and unfortunately ended up in the High Court eventually.
All right, so the issue wasn't really about the standard of education, but just this term, Section 26(1) of the Legal Practice Act, that says that only students from public universities are allowed to enter the legal profession.
That's
and
correct.
So you were saying, hang on, okay, we're not allowed to be called universities, but our students are studying the same things and are as qualified. So now what this means is that the minister has to change the Legal Practices Act. Is that correct?
To change that word from using the word university to a higher education institutions,
Okay.
which of course includes universities and those who can't call themselves universities.
All right, some people might say it's semantics, so that the Law Society and the legal profession itself was going to be quite adamant without this legislation being changed that if you didn't go to a public university, no matter what qualification you got, you couldn't come in.
Correct. That was the stance at the time, and that's why we're very grateful for Judge Sibiya, who declared that the use of the word constitutionally invalid insofar as it prevented students coming from a private education background, even though they follow the same curricula, or at least similar curricula, accredited curricula, from entering the profession.
So who did you take to court?
Well, essentially the KwaZulu-Natal Law Society, but we had a number of defendants, both in support and against, but effectively it was against.
So the Law Society was fighting you on what basis, though? Because they can see that it really is just about words.
Well, I guess if you're a lawyer, you stick to the word of the law, and in this case it was university, and we're not a university, so that's the only basis I can see that the argument was based on. If you're a lawyer, you stick to the law.
I suppose historically what's probably happened is that there weren't any institutions like yours that were offering LLB degrees, and therefore the only place you really got this was at a university, and so the words weren't consequential at that time.
Certainly, we're only the second private higher education institution that has an LLB accredited. We're the first one with a 4-year LLB. So it's something new on the table. I mean, it was somewhat unexpected. The processes from an educational perspective were followed, and then we picked up on this. So it is new to everybody as well.
They're not going to appeal this or do you know?
I really hope not. I don't think so.
So what does that mean? The students that are currently enrolled at the moment, they're only graduating in a few years' time anyway. By the time they graduate, in theory, the law will have been changed.
Correct. I mean, as you would have seen, the judge gave 1 year, suspended 1 year for this change to happen. Our students are only in their second year of study, and it is a 4-year degree, so we have time on our side. But we're confident that this change will go through.
All right, so looking, because you teach more than just LLBs, I wonder, are there other professions, engineering perhaps, that might have this kind of legalistic problem? Is this something that you're investigating?
Certainly, if you broadly speak, the four, I mean, of course, there are more than four, but the four professions, the health professions, the chartered accountants, the engineering and the legal professions. As far as the South African Institute of Chartered Accountants are concerned, we are accredited with them, so we have a Bachelor of Accounting degree accredited by SAICA, so we haven't experienced any similar issues. And certainly in the engineering field, there are other private institutions that are accredited with places like EXA, so we don't foresee any future problems, but we'll certainly keep our eyes wider open next time.
All right. Peter Kriel, thanks very much indeed for going to get this clarity, because I'm sure a lot of students are very, very relieved with this outcome. Thanks very much indeed for joining us. Thank you.